So Alan, let's talk about the exciting world of the law and what Bitcoiners, especially Bitcoiners starting business, should be thinking about. Alan is a transactional attorney, and he's also a Bitcoiner, so that's probably the more important thing in the room. But his knowledge in working with entrepreneurs and emerging companies and advising them at the startup stage and what they need to know early on is important because it helps avoid trouble, expense, and exposure down the road. Alan, tell us a little bit about yourself before we get started.
Sure. Thanks. Hey, everybody. My name is Alan Bickerstaff again. I am a corporate transactions attorney. Pretty well known in the venture capital and startup community in Austin. I've been here since 1999, representing startups and high growth companies, literally from like formation through exit. So that means two people with a business plan and idea and nothing else come in, help them form the corporation, take them through multiple stages of equity financings, typically venture capital backed companies, and then sell the company in an M&A transaction or take it public in an IPO, depending on what the exit strategy is. So I've been doing this for quite a long time now. I've done hundreds of venture capital financings at this point, hundreds of M&A transactions and IPOs, and have counseled multiple entrepreneurs on just about everything you can imagine all throughout the life cycle of a company. So that's kind of the business model. My journey with Bitcoin began in 2013. I was at a South by Southwest party and I met this guy who looked like he was 14, honestly. He was super young. I asked him what he did for a living, and he said, well, I just graduated from college, but I'm retired. And I said, really? I said, how did you do that? And he said, well, I was mining Bitcoin the entire time I was in college. So this is like early 2013, right? And I went home that night, I downloaded the white paper, read it, didn't quite get it, did nothing because I didn't know what to do at the time, and I got busy with work and what have you, so that was a missed opportunity. Luckily, got back in early 2017 and really started getting it, and have been a fanatic about Bitcoin ever since. So, and then started listening to all the podcasts with Michael Saylor and Preston Pish and a lot of these guys, and really learned it and understood it, and now I'm just a huge fan about it. So I'm with a firm named DLA Piper. We're a global law firm. One of the core roots of our firm was a Silicon Valley-based law firm. Started in 1969. Started representing some of the original startups in Silicon Valley, and has grown to a global law firm today. And the emerging growth of venture capital practice is still a key part of what we do. I'm the Texas head of venture capital and emerging growth of venture capital. And again, so that's what I do, counsel startups, entrepreneurs, from the very earliest stages all the way up to the high growth stages. Is that enough?
Yep.
Good.
Thank you. So Alan, let's go ahead and kind of walk through the life cycle, at least at the early stage, the hurdles that a startup founder, a team, a set of entrepreneurs might encounter. So when you think about company formation, because that's the first thing, just to be a legal entity, there's a couple different choices someone would have. A partnership, an LLC, a corporation, S Corp, so on. There's the four big ones.
Right.
What do you recommend, and what should startup founders consider, and how does that relate to how a VC might look at their entity?
Right. So good question. Every situation is different, of course, but generally speaking, if your goal is to raise institutional capital, you're probably almost certainly going to start a C Corp, a C corporation, and you're probably going to incorporate in Delaware. Well, there's a little bit of question these days with the Elon Musk case. There's some people who are kind of really objecting to Delaware and whether some of the judges there are making decisions based on politics as opposed to the law. So there's a little bit of a shift. I haven't seen a tidal wave yet, but you've been seeing some bigger companies move to other jurisdictions. But for now, Delaware is still kind of like the federal corporate law of the U.S. for the moment, because everybody knows it and everybody understands it. The NVCA documents are all tied to Delaware and Delaware law. So, it'll take some time for that to change, and maybe it will change, but for now it's Delaware. So there's some advantages to a C Corp that are helpful. It's a tried and true path. It is consistent with what I'd call the KISS principle, which is keep it simple, stupid. VCs know it, they understand it. The things you do to set up an equity incentive plan are all, very well worn paths, very well known, very understood. So you can kind of do things quickly, efficiently, without spending a lot of money on lawyers' fees, figuring out transaction structure and tax optimization and all that. I'll cover a little bit in a minute, but one of the things you get with a C Corp also at the startup phase is there's this tax benefit called qualified small business stock. And if you set up your C Corp properly and you have what's called a qualified trader business, as long as you hold your stock for at least 5 years, you get tax-free capital gains up to the greater of $10 million or 10 times your basis in your stock. So as a founder, you're typically going to pay 1/1000th of a penny per share when you buy your stock in the corporation. So your basis is not going to be very much. So you're going to end up with the $10 million cap. But for your investors who actually invest money, for example, say $5 million in your first institutional round, that equates to a $50 million tax-free capital gain potentially. And we have clients that actually, they'll set up an LLC initially and, build it up to the point where it's just below the cap for a QSBS eligible entity, convert to a C Corp, say like $45 million of value, and have a $450 million tax-free capital gain built in if they can build up the business that large. So, so the short answer is almost certainly a C Corp. There are circumstances where an LLC makes sense, and that's where it makes sense to kind of talk to a lawyer, try to understand your objectives, your business objectives, what you want to do, and those all kind of tie into making the decision about what kind of entity to form.
Great, thank you. Part of the initial process also is equity and who you share that with and how much. Right. And that can be for investors as well as for employees. So let us know some perspective that founders should have with respect to their own equity, sharing equity with investors, what to contemplate before signing on the dotted line, and then separately, once they start building their team, how do they look at compensating the team that includes equity? Right.
Very good question. So this kind of ties into the first question as to what's the best business entity to start your startup. When you're setting up a new entity, if you have multiple founders, I think the first thing to keep in mind is figuring out who's a founder and who's not, right? That group of people is essentially going to acquire the first issuances of stock in the corporation. And when you have multiple people, I always recommend that you put vesting on your shares. The reason is you want every founder to be committed to the enterprise. And what vesting does is it forces that mechanism. It's got a forcing function in it where if you're not going to contribute or somebody doesn't work out and they leave after 3 months or whatever it is, you've got an automatic contractual mechanism built into your documents where you can repurchase the unvested shares. And those founders who are going to continue on with the business own a proportionally larger share of the business because the denominator's just gone down, right? Because you've reduced the outstanding shares. That's huge, right? Because I've seen multiple times where one founder doesn't work out for multiple reasons, right? And if you don't have this mechanism built in, it's very difficult and expensive to try and get those shares back from that founder. And I've actually seen companies be unfundable because VCs will come along, they'll look at this and say, well, why does this guy own 25% of the cap table? Like, that's a bunch of dead equity, right? People are going to have to be committed to work 68 hours a week, build this enterprise, and this guy's going to get a free ride. So that's very important from the founder perspective. Second thing you do when you form the entity is you'll create an equity incentive plan, typically 15 to 20% of the fully diluted capitalization. And that's available for issuing stock options to your early employees and your future employees so you can give them an equity incentive to contribute to the business and to help build up the business. And that creates the equity incentive for the employees. And then finally, when you're ready to raise capital, you'll negotiate with an investor or investors to design a security that will allow the investors to put money into your enterprise to fund your operations and to go out and build the business and give them a certain basket of rights that are a pretty well-known basket of rights. Like if you search National Venture Capital Association, they've got a page on their website that has the forms that most people use in the industry these days. And you can go look at those and kind of get a sense for, what that looks like. It's probably 250 pages of junk and, a lawyer could probably talk to you in about 15 minutes and kind of explain it at a high level, but effectively what you're doing is you're issuing a preferred stock security to your investors. It's got superior rights, preferences, and privileges. And the reason you do that is, one, they're putting money in, and so they want to be, if they're putting money in, they want to get their money out first. And then secondly, the differential between the rights and preferences and privileges of a preferred stock security versus the common stock security makes the common stock less valuable. So what that allows you to do is grant stock options to your employees at a price that is a discount to the market price or the headline price at which you sold your securities. So for example, if you raise money at $1 per share with your preferred stock in your first institutional round, you can price your options at maybe 15 or 20 cents a share. So although there's a discount, right, as time goes on and the enterprise builds, the discount closes, right, converges into the same price, so that in the end, if you've done the right thing, you built value, then everybody cashes out. The preferred stock effectively converts, and everybody just cashes out on a one-for-one basis, and the common stock's worth as much as the preferred stock. So it kind of creates that equity incentive for your employees, if that makes sense. So hopefully that's helpful.
I'm going to hand this one right back to you. This is a short question. So you're getting started, and you've got a brand and a tagline and a certain way that you go about doing your business that's rather proprietary. So how does a startup protect its intellectual property?
Another great question. So there's several layers, right? So the first layer is that formation. Part of the founders committing to the enterprise is what we do in our initial stock purchase agreement for the founders. We build an IP assignment agreement. So everybody commits to assign whatever rights they may or may not have, or may have rather, in the kind of the esoteric IP, the business idea. Maybe you've got some code, whatever it is at the early stages, right? You're going to assign all that to the corporation as part of the consideration for your stock. So that's point one. Everybody puts the IP in the corporate vessel. The corporate vessel is now the owner of the intellectual property, and that helps make you fundable. Point two is all the founders and all employees will sign what's called a proprietary information agreement. So this thing does several things. One, it's got an NDA built into it that requires the employees to keep the information confidential. Two, it has IP assignment provisions in it to make clear that everything you do for the corporation is assigned to and owned by the corporation. Another key issue that key due diligence item that investors will look at whenever they're looking to invest in your company. Those are super basic. I can't tell you how many times those issues come up in the financing process and the M&A process. You got 10 employees who never signed their PIA and they're coders or they own a patent or whatever. And it's like a huge issue, like it's a showstopper. Literally, you cannot close that financing, you cannot close that M&A transaction until you get those people to sign something assigning ownership to the corporation. So you got to build into your processes day one, right? You got your HR stuff that you got to complete for the employees. And one of the things that's got to be on that list is this proprietary information agreement I'm talking about. When dealing with contractors, and this is really important, that trips up a lot of people. If you have somebody that's not an employee who is developing intellectual property for your enterprise, the common law is that the contractor owns whatever they create, unless you have a written agreement that specifies otherwise that they're assigning ownership to the corporation. So a lot of people trip up on that. They don't have the right assignment clauses. Again, multiple horror stories, running around, scrambling, trying to find contractor X to sign an agreement before we can close the financing or a sell-side M&A transaction. So that's really important. And then finally, NDAs. When you're dealing with third parties, have everybody sign an NDA. We include as part of our startup incorporation package a pretty customary middle-of-the-road NDA to make it easy for people to use, so they don't have to spend a lot of time negotiating back and forth on the NDA. It's fair to both sides. It doesn't it's not so one-sided you end up like having to go back and forth and negotiate a lot of things. So that's kind of the basket of tools I think you would use to protect your intellectual property. And then of course, if you have patentable inventions, you'll want to talk to an IP attorney so that you can patent that invention and create a moat around your technology and potentially your business model, depending on what the patent is. And of course, trademarks also are registrable. So I think that's all. Think about it as like the code of your IP, right? There's a lot of developers in here writing code, right? So think about all this as your legal code. You've got your code that protects your intellectual property. These are the things you got to do. These are actions you got to take. And then there's the capitalization code, which I'm sure we'll talk about in a minute.
But first, if you're doing all this, you're accumulating records and documents, and they need to be maintained in a particular way. Have somebody to kind of organize those, not only through a file system online, but sometimes, have printed copies or have them easily made available. Because, for example, we have a gentleman here with Satoshi Pacioli, which, if you're not familiar, is a very Bitcoin-friendly CPA business based out of Nashville. And obviously, we have a practicing attorney here, and there may be situations where entities like each of them would be looking for your documents, as well as the state's comptroller or the IRS. So tell us a little bit about maintaining corporate records, the importance of that. It's kind of obvious, but are there ones in particular that you really want to make sure you keep track of?
Yeah. Now, another great question. So I guess this is what I'd think about it as the code of your startup. And it really relates to a lot of things we already talked about. So first of all, capitalization, super important to be able to document exactly every single share that goes in or out of your corporation, how it was issued, who it was issued to, et cetera. Because that's going to be a critical gating item to just being able to raise any money from investors. And in an exit, right, when you're selling the company, there's all this, these representations and warranties about the ownership of the business, and you'll have this long thing called a merger consideration schedule that lists every single stockholder, how much they're getting, how much they have to contribute to escrow, et cetera. And so that information has to be super accurate. So, it's hard, it's a pain at the beginning trying to keep all these records together, but you got to keep your records in order. Set up a file system, a Dropbox, or some sort of file system, so that when you create these things, you've got a folder for corporate records, you've got a folder for capitalization. You could also go use some capitalization software like Carta, and there are others. Carta's pretty expensive. There are others that are cheaper, but bottom line is it's software that you can use online that helps you maintain your capitalization, and it does a good job of tracking things, numbering the certificates, issuing electronic certificates, paper certificates, all those sorts of things. That's super important. And then, what I was talking about before, documenting your IP, ownership of your intellectual property. So making sure all the employees have signed a PIA, right? Making sure you have copies of all of your NDAs and your contractor agreements. Again, those are things that people are going to have to check the box. If you're trying to raise money or you're trying to sell your business, these people are going to pour through every single document you ever created and make sure you've got these things and look for the holes. And if there are holes, you're going to make you fix them. So much better to try and get your process in place. Make sure you got a file system. You get these things signed at the upfront at the time of the engagement, et cetera. It's super important. So what do we got? So we got capitalization, intellectual property. I guess we could talk about data privacy a little bit. Mm-hmm. So I'm not a data privacy person, but if your business model involves what would be called client information, private information, personal information, PII, personal information. I forget what PII stands for. But basically, names, addresses, phone numbers, particularly of consumers. If you're consumer facing, there are all kinds of overlapping data laws out there. California's got one. You've got GDPR in Europe, and more states are passing them. And it gets to be super complicated to comply with that stuff. And you really got to spend some time making sure you're complying and that you got the right security protocols in place. Because if you have a data leak, the damages are massive. You're going to have every plaintiff's lawyer in the world coming after you, trying to sue you and beat something out of you. And it just costs a ton of money, not only to pay all that out, but also to pay your attorneys to defend you. Attorneys, consultants, et cetera. So super important if you've got that kind of business model. talk to somebody, make sure you've got the right protocols in place to protect data and personal information. Richard IP, let's see what we got. IP records, corporate, your corporate records. With a corporation, you have to have a board of directors who takes actions and approves certain material things, in particular the issuance of securities, right? So when you're issuing securities, you always got to document that with a board consent. And you need to have your what I'll call your corporate records code, right, where you've maintained all these board consents in a folder structure that I was talking about before. Sometimes stockholder consent is required to do certain things. You want copies of all those consents in your records, because again, those are things that your investors are going to want to see before they're going to put money in, and it's something that your acquirer is going to look at before they're going to buy your business. So I think that covers the things we talked about, right? And your license agreement. Sorry, one more thing. One more. Third-party license agreements, right? So again, right, a lot of you are going to have inbound licenses. Sometimes it's outbound licenses, customer contracts, all those things. Those are going to be huge. Again, you got to make sure you maintain those, understand where they are, be able to produce them. If you have funky things like MFNs, most favored nation pricing clauses, exclusivity provisions, things like that, those are good to note. If ideally track that in a spreadsheet. Contract X, we gave an MFN or we gave an exclusivity provision. Here's how it works, because all that stuff will come up very specifically. It'll be very specific, detailed questions about that in your diligence process. Yeah.
Thank you. Yeah. And you mentioned plaintiffs' attorneys in your last response. Those are the ones that you typically see more often on billboards and TV, if you think about traffic accidents, something like that. But the types of lawyers that a startup might need aren't necessarily the ones that they're familiar with or hearing all the time. So what is something to think about when trying to hire an attorney just to help them get the startup going? And what are the key 2 or 3 different types of attorneys that they might, practice areas that might be good for a startup to at least get to know, have as an advisor, or possibly engage?
Yeah, another great question. Hire the right person for the right job. I mean, first off, I think if your goal is to build a startup and raise institutional capital, you should find an attorney that has a lot of experience in that space. Ideally, it's all they do, because they're going to know market dynamics, can give you a sense of what's market in terms of like the terms, valuations, all the things you're going to run into when you're trying to raise capital, and they should have like a tried and true system of forms to be able to set up your corporation with all the stuff I was just talking about very quickly, efficiently, and easily, so that when you go out and raise money, you're going to check all the boxes that the investors are looking for when they want to invest in your company, right? You've got the right capitalization, you've got the founders subject to vesting, everybody signed an IP assignment agreement, and you've protected your IP with PIAs for all of your employees, and you've got contractor agreements, et cetera. Hiring your estates plan attorney, or your divorce attorney, or the guy who did your speeding traffic ticket, it's just not going to work. I've seen that many times, and I've seen the results, and you end up spending at least 10 times the amount of money to clean that stuff up as if you just done it right in the first place. So do a little digging, do a little research, ask for referrals, talk to people, try to find that right person, because it makes a big difference, right? I mean, if somebody came to me with like an aircraft leasing deal, I'm going to be like, I'm not the guy to do that. Yeah. I've got people in my debt group who will go do that. Yeah. I would screw that up for sure. So getting the right person, I think, is super important. If you're going to, if you've got patentable inventions, find a good patent attorney. It needs to be somebody who's not just a patent attorney, but if you're in the semiconductor space, you ideally want somebody who's got experience in semiconductors, right, and understands the ins and outs, because every focus area has little nuances about it that you really can only learn and understand with experience. So getting the right person to do that stuff is good. It's worth it to take the extra time and effort to do some research and find the right people.
Thank you.
Hopefully that helps.
Yeah. So we only have 2 more items. They're more just commentary. And since you mentioned estate planning attorneys, I believe I may have mentioned this last year, but I always like to share this with people because even though I am not a practicing attorney, one of the key things that I took away from law school that is helpful that I always remind friends, I periodically share this over my business social media at least once a year. By a show of hands, please, because I know some of you in here are business owners and or have a family. Raise your hands if you have a will. Not too many. You should have a will because if you don't, what you have in your belongings will escheat, I love that word, to the state. It'll just, big chunk of about 50%, right? Will go to the state. If you don't have a designation about what you want to leave to your heirs or maybe to a nonprofit, charity, something like that, if you don't designate it, the state will figure it out for you. And they do that in a lot of situations when we don't step up and take care of things ourselves. So if you care about your privacy, your family's future, please put a will together. And Texas is one of the states that allows you to just write it down with a pen and paper in your handwriting. That's your will. You don't have to have an attorney for that in Texas for it to be a viable will. However, working with an attorney for those kind of things, and I really want to emphasize, I encourage you to work with an attorney in creating your will and making sure that all of your wishes as you understand them to be executed will be written down and captured that way, as opposed to going online with one of the popular entities that will get you a will done for $200. That's great now, but 20 years from now, when situations change, you may find out that that will does not, you wouldn't find out because if situations have changed. It could be that you're not around. You don't want to have your family discover something that you thought would be there for them that's not, because the will was rather flimsy, as can happen. And there was one other point tied to that I was going to make, but that's enough on that. Last year we also did mention the CTABOI, that is the Corporate Transparency Act, Beneficial Ownership Information Requirement. Because as of last January, the Biden administration had put forth a requirement that a lot of small business owners, entrepreneurs, LLCs didn't even know about, and yet you would have been on the hook for. Or if you formed an LLC last year, you had to file within about, I think, 60, 90 days.
90 days.
You had a short deadline. If it was a company that had already been established before January, you had until the end of the year. And the prevailing more conservative thought was, hang on, because we're probably going to legislate this or go back and forth on it, so don't file anything yet, because you were going to have to be asked to comply and give up a lot of inside information about your company, your ownership, and things like that. The government's effort on this was to avoid money laundering and have transparency about ownership, so we didn't have any nefarious actors, and that's all well and good, but it was basically government overreach. And then in comes the Trump administration. So that was part of the waiting game, was hoping that with a new president elected, possibly in November, the thinking last year was that this might not be enforced. And I think that's where we are, even though we played a good game of tennis last year, going back and forth in the courts and the appellate courts and also the Supreme Court with, it's on again, it's off again, the deadline is moved. The deadline right now to file your information is March 21st, and that's the end of next week, that's next Friday. But you do not have to comply right now. According to FinCEN, their website, they're not going to enforce, and the Department of Treasury is not going to enforce. So if you have any questions, Michael here in this Satoshi Pacioli t-shirt might be able to answer that for you, because although it is kind of some legal field there, it's more in the CPA world as far as how you would have to comply and the paperwork you would need to fill out. So I think the majority of us in the room are just going to sit tight and kind of, since they're not going to enforce it, we're probably not going to comply. You need to speak to your CPA and your attorney and your business team to figure out how you want to handle that. I want to make sure that you all were aware of the latest update on that. Do you have any other comments?
Yes. On the will thing, totally echo what you're saying. So Texas has a statute that's got an intestacy statute. If you don't have a will, then it tells you how your stuff is going to be distributed to, your parents or your children or your grandparents. It kind of goes out. They just keep going out. 3 cousins out until they find somebody that's related to you and they get your stuff, your wealth. And so if you don't want your money distributed that way, you definitely got to do a will. I actually have a friend who had this situation occur last year. A very good friend and family friend died, didn't have a will, and basically, literally, there's no family that they could get in touch with, and so his stuff in his apartment, his condo is going to sit there, his car is going to sit there, and it's just going to sit there, and it's just going to sit there until it gets foreclosed. What's going to happen is the state's going to foreclose on the condo for failure to pay property taxes. It's going to get sold in an auction to pay the property taxes. All his stuff will get sold, his car will get sold, and that'll all just go to the state, ultimately. It's a mess. On the CTA, yeah, so that's exactly right. So March 21st is technically the deadline to file, but they've said they're not going to enforce fines or penalties, and they plan on coming up with an interim rule before March 21st that is going to extend the deadlines. And a lot of people are hoping it's just going to die entirely, but that's not clear yet. So we'll see what happens. And then I've got one more hot take if you want. So Trump's executive order on DEI. So basically, the executive order basically makes, quote unquote, illegal DEI practices and policies in the federal government and in the private sector, and mandates that you can't use race, sex, gender identity, sexual preference, and religion in employment decisions in lieu of individual initiative, skills, performance, and hard work. The executive order doesn't define illegal DEI. What they said is the Attorney General is going to study the issue and come out with the definition sometime in the next 120 days. So we expect that's going to happen, and that's maybe going to give more insight into what's happening. But in the meantime, if you have some sort of DEI policy in place, you should think about that, look at it carefully in light of what's in the executive order, and decide whether you need to make changes in order to comply with this so that they don't come down on you eventually.
Sounds great. And last but not least, one of our other sponsors, DLA Piper and Alan Bickerstaff. Thank you very much. Alan, thank you for being here today.